fine is state. Okay.
Obliged, deeply obliged.
Item number 2.
Section 442, 406, 467, 468, 465, 472, 102 DP, IBCD section 456 of the IRT circular.
OPID Act, have you given a copy to
Yes, I have
Mr.
given the copy.
Mr. Patra? You have received the copy of the appeal memo? Yes.
Extra copy is served.
No, Lordship, I have given the copy. Receipt is there.
So in mood second. দেখিলে এটা clear কি receive করবে।
Right.
Okay. So what is the operative part of the judgment?
52 miler.
52.
52 mile. 5 years.
Just a minute. RI for 5 years, 1 lakh. In default, so on so 6 OPID. Then 3 years, 20,000. In default, okay, 420 by 34. Then 2 years, 20,000 in default. So on so for 3 months, 406. Then RI for 2 years, 20,000. Okay, in default, so on so 465. 3 years, 20,000. 467. 2 years, 20,000. Okay. All the sentences are to run concurrently, right? So the highest one is 5 years, na?
Miler.
And your position during trial, you are on bail.
Bail, miler. 16/5/2000 arrested and 26/9/2013 released.
Yes, that is there.
Miler.
Yes, Mr. Patron,
Miller.
admit he was on bail granted. In after conviction, he has been taken into judicial custody. Bail allowed, stay realization of fine. Free copy of the order be handed over to Mr. Patron. And special counsel appearing for the state of Orissa in OPID Act matter.
Mr. Bivani also mentioned.
And name of henceforth name of Vivekanand Bhuya and Mr. Patra be reflected in the cause list.
May I please, my lord? Item 273, same, another accused.
273
item.
273.
My another accused. Same judgment.
Same judgment.
My
273 টা বার করলে আদের ডিফেক্ট রয়েছে কপি নট সর্ট বলি
yes, my I have sought.
দেই দিই জানি মানে
Yes,
ଅଛି তো
ঠিক
প্রুফ
আছে।
ଅଛି ତ মিস্টার পাত্র মুটিয়ে দেখাই দেন
Two extra copy be served.
অলরাইট এক্সট্রা কপিজ বি সার্ভড করে দিଅନ୍ତୁ সেম জজমেন্ট ଆଉ
Same judgment, my lord. 1-2. Present petition is up.
wait. Alright, copy served, extra copy to be called then. Baki rest of the order similarly like item number. Admit, bail granted, stay fine, similar to item number 2. Okay.
Okay.
Next.
Item number 3.
May I please, Your Lordship? Here the appellant convicted under section. Here the appellant convicted under section 13(2) read with section 13(1)(d) and section 7 of PC Act.
Mr. Das, you have received the copy of the appeal memo?
Yes, my lord, I have received and also I have filed my appearance memo on 15/9/23.
23. What is the operative part of the judgment?
Running page 10.
Running page 10. No, that is not the. Come to the
Internal
end of
page 49, running page 57, 58.
57.
Okay.
57.
RI for 2 years, 5,000 in default to undergo RI for 3 months under section 7 of the PC Act. Then RI for 3 years, 5,000 in default so on so 13(1)(d), 2. Okay. What is the bribe money?
3,500.
Okay. What is the powder which is used smeared on the tinted notes? What is the name of that powder? And what is the solution which is prepared in which hand wash is taken? Have you read the judgment? How a draft case preparation is made? Somebody makes a complaint, then a date is fixed for preparation. How the preparation is made? And how ordinarily a person is trapped in any office or in his residence, a public servant is trapped. What is the procedure laid down? Or what is followed in such type of cases? Have you heard any word called decoy?
I have read the judgment. From that, I
What do you mean by decoy?
see that.
What is a shadow witness in a trap case? Once your senior has assigned, you should read thoroughly. You have already got 2 holidays. Saturday was a holiday and Sunday was a holiday. So once you read the judgment in such type of cases, you'll know it's a senior has entrusted you to argue the matter in the High Court. So it is your duty also to read it thoroughly, and if any doubt is there, you should ask your senior. Right? What is your good name?
Khageshwar Beher.
Khageshwar Behra. Admit, call for the trial court record. He was on bail, bail allowed, stay realization of fine. Mr. Das submits that he has already filed the appearance memo on 15/9/2023. Same be taken on record, henceforth the name of Mr. Das be reflected in the cause list. Free copy of the order be handed over to the learned counsel for the standing counsel for the vigilance department. Yes, next.
Item number 4.
I submit my lord. Page 26, your lordship has granted leave to submit the appeal memo. 26, 27, page 27, your lordship has granted leave to submit the appeal memo.
27.
My lord.
All right, heart admit. Call for the trial court as well as appellate court records. The learned trial court shall issue notice to the respondent number 2. What is his name?
Vidyadhar Panigrahi.
Vidyadhar Panigrahi. ये उनका दियो CRPC का. All right, empty कर दूँ. Issue bailable warrant of arrest against the opposite party respondent number 2, and on his appearance before the Learned Trial Court, that is SDGM Bhavani Patna, in 1cc case number 491 of 2018, he shall be released on bail. All right, you do one thing, bailable warrant of arrest করবেন, and indicating therein that the matter is fixed before this court on such and such date, and if he is at liberty to engage counsel, intimation will also be given to the Learned Trial Court. So, in view of section 390 CRPC, issue bailable warrant of arrest. And on being arrested, the arresting officer shall release him on bail and communicate the same to the Learned Trial Court, that is SDGM Bhavani Patna, in 1cc case number 491 of 2018, which will in turn be intimated to this court. Okay, and it will be intimated to the petitioner that the date is fixed to such and such date. He is at liberty to appear through the counsel. Okay, yeah. IA रे ଗୋଟେ କଣ exemption file କରିଛନ୍ତି original certified
copy.
You have filed, have you not filed?
Certified copy already submitted to district.
That's that trial court judgment
minor.
and appellate court judgment certified copy file କରିଛନ୍ତି.
ଆଜ୍ଞା, ये पूर्व CLP रे CRLP रे करते.
All right. The learned counsel for the IA number so and so 2 months is granted to the learned counsel for the appellant to obtain the certified copy of the trial court order and file the same before this court. Ajigali au original case record eti asuni xerox copy ta aସୁଛି ହେଲା, ତେଣୁ original ସେଠି ରହିଯାଉଛି, ସେଠୁ certified copy ଟା apply କରିକିନି file କରିବେ, 2 ମାସ ଆପଣଙ୍କୁ ସମୟ ଦିଆଗଲା. Yes, IA is disposed of.
Item number 5.
May I please, Lordship?
Yeah.
Appellant convicted under section 13(2), reduce 13(1)(c)(d) of the Prevention of Corruption Act and offense under section 409.
Mr. Das, have you
Yes, my lord. I have received and I have filed my appearance memo on 16/9. So no.
what is the operative part of the judgment?
Part of the judgment, running page 64, Lordship. 64. Conviction under section 409 IPC is sentenced to suffer arraign for 2 years and pay a fine of rupees 20,000 and default to suffer arraign for 2 months on conviction 477A of the IPC. Suffer arraign for 1 year on conviction under section 13(2), read with section 13(1)(c) of the Prevention of Corruption Act. Suffer arraign for one year and pay a fine of rupees 10,000. In default to arraign for 1 year, 1 month, and on conviction or section 13(2), read with section 13(1)(d)(2) of the Prevention of Corruption Act. Arraign for 1 year and pay a fine of rupees 10,000. Run concurrently.
So it's 2 years, no?
2 years.
You are on bail during trial?
Yes.
Yes, Mr. Das.
Yes, my lord.
Or admit Mr. Das submits that he has already filed the appearance memo on 16/9/2023. Registry shall place the same on record, and so the name of Mr. Das be reflected in the cause list He was on bail, bail allowed, stay realization of fine. Free copy of the order be handed over to Mr. Das. Yes.
Item number 6.
Increment, my lord, 10 years, my lord. No, sir, 9-2.
My lord, I may be pardoned. My lord, appellant has been convicted under section 13(2), read with 13(1)(d) and section 7 of PC Act. My lord, the
Please
operating,
come to the operating
my lord,
part.
running page 57, my lord.
Read it out.
My lord, the convict is sentenced to undergo RI for 1 year and to pay a fine of rupees 5,000, and in default thereof to undergo RI for 1 month more for commission of the offence under section 7 of the PC Act, and to undergo RI for a period of 2 years and to pay a fine of rupees 10,000, and in default thereof RI for 3 months for commission of the offence under section 13(1)(d) of PC Act. The sentences are to run concurrently.
So
The-
it's 2 years,
2
right?
years.
And you were on bail during trial.
Throughout.
Yes, Mr. Das.
I will file my appearance memo by the end of October, my lord.
Okay. I admit will file the appearance memo by end of October. He was on bail, bail allowed, stay realization of free copy of the order be handed over to Mr. Das.
Item number 7.
Item 7. The appellant convicted under section 13(2), read with 13(1)(d) and section 7 of the PC Act. My lord, find from the operative portion, page 97.
90?
96, my lord.
But-
Para 29.
Wait. Yes, one appellant.
Yes, it's one appellant.
So, Mr. Das,
My lord, I have received the copies. I will file my appearance memo by the end of October.
okay. Yes, Mr. Pradhan, come to the operative parties.
Yes.
Page
RI
96.
for 2 years and fine of rupees 3,000.
Wait.
Page 96. Para 29.
2 years.
Yes, page 23.
All right. Admit Mr. Sanjay Kumar Das, Learned Standing Counsel for the Vigilance Department, submits that he has received the copy of the appeal memo, impugned judgment, and copies of the interim applications. And he will file the appearance memo by end of October 2023. Admit he was on bail, bail allowed, stay realization of fine. Free copy of the order be handed over to Mr. Das. Yes.
Item number 8.
May I please, your lord?
Undergo rigorous imprisonment for 10 years and to pay fine rupees 1 lakh.
Right. Admit interim applications for bail and stay realization of fine to be considered after receipt of the trial court. Deposition copy to be supplied in the meantime to the Learned Counsel for the state.
Obliged.
Item number 10.
Mr. Manoranjan Muduli. What is this criminal appeal, Mr. Das?
My lord, 10 years under section 376 2I, my lord. 10,000 fine.
Operative parties.
My lord, 47 days. 46 start, my lord. Last part. 32. Paragraph.
Okay. Accused is found guilty, so and so. Convict is sentenced to arrive for 10 years. Okay. All right, hard admit, call for the trial court record. Bail application to be considered after receipt of the trial court record. The land counsel for the appellant shall supply the deposition copies of the witnesses to the land counsel for the state in the meantime.
Item number 11.
May I please, your lordship. The appellant is convicted under section 7 and 13(2), reduce section 31D of the PC Act, your lordship. The operative part is running page 42.
42,
your lordship. Running page.
one appellant.
Yes, your lordship.
So 1 year, 3,000 in default undergo RI for 2 months. 7 PC Act. Then RI for 2 years, 5,000 in default to undergo RI for 3 months. 13 to 13(1)(d) run concurrently. Okay. So it's 2 years. You were on bail during trial?
Yes, your lordship.
Yes, Mr. Das, you have received
Yes,
the
my lord.
copy?
Yes, I have received. I will file my appearance by the end of October.
Okay. Admit, hard admit, call for the trial court record. Mr. Sanjay Kumar Das submits that he will file the appearance memo by end of October 2023. He was on bail, bail allowed, stay realization of fine. Free copy of the order be handed over to Mr. Das. Henceforth, his name shall be reflected in the top of the brief as well as in the cause list. Yeah.
Obliged, lordship.
Obliged.
Item number 12.
My lord, on behalf of S.K. Bhandhu, pray for password.
এটা কোন SC/ST bail matter?
No, my lord. Challenging order of acquittal.
Acquittal. Okay. Even Mr. Nanda, you are there?
Yes.
All right, pass over.
Item number 13.
Item 13 on behalf of Mr. Panda kindly taken over after puja vacation. Obliged.
এরা কোন conviction case?
Fine.
All right, after Dasara Puja vacation.
Item number 14.
May I please, your lordship. Petition was
Please use the mic properly.
My lord. The petition is in custody since 13/11/2019. In the meantime,
What is this criminal appeal?
as because there were 3 SC/ST offenses.
3 SC/ST bail.
My lord, earlier it was rejected as BLAPL 386 of 2021 by Honorable Justice B. Nursing. My lord.
Yeah, some of the co-accused persons have granted bail by this
302 is there after charge sheet, my lord. The SC/ST added, my lord.
No, this should be the first bail application. ଯଦି କାହା ପାଖରେ ହେଇଛି
ଆପଣଙ୍କ ପାଖରେ ହେଇଥିଲା
କେତେ ନମ୍ବର ସେଟା?
BLAPL 8813 and another is 6372 of 2020.
8813 ତ ଅଛି, 6372 ବି ଅଛି। ସେଗୁଡା ଡେଟ୍ ଅଫ ଡିସ୍ପୋଜାଲ କେବେ ଥିଲା?
Date of disposal ହଉଛି 17 February 2021 and another is 16 November 2020.
2020 ଟା ପ୍ରଥମ,
ମାର-
ଆଉ ଯୋଉ ଜଷ୍ଟିସ ନରସିଂହଙ୍କ କଥା କହୁଛନ୍ତି କେବେ?
ସେଟା ହେଇଛି your lordship, that was decided in 11/5/2022.
Then it's Mr. Das. ପ୍ରଥମଟା ମୁଁ ଡିଲ୍ କରିଛି। So yes, what is the date of custody?
Petition is in custody.
Let me obtain the CD, my lord, because CD has
CD ଆହିଁ notice ଯାଇଥିଲା, notice sufficient ହେଇଛି ନା ନାଇଁ?
notice, my lord, sufficient, my lord.
Okay, the learned counsel for the state submits that notice on the informant has been made sufficient. Kebe date
28/2023
28/2023. None appears for the informant. The Land Council for the state 1 week time to obtain the case diary and a further 1 week time to produce the case diary as well as obtain instruction regarding the criminal antecedent if any against the appellant. Please this matter. Asi hobo next week re? Na gote week pore go.
What type of?
So keep it then.
Also the status report, the trial has already commenced.
Acha status report मगे दियंतु October 3 तारीख रखी दियंतु. Third of
Prefer 4 my lord.
ସେଇ 3 ତାରିଖ 4 ତାରିଖର ଲିଷ୍ଟ ଆସିବ କିଛି ଅସୁବିଧା ନାହିଁ. ଯେ ଛୁଟି ଅଛି ତ ଗୋଟେ ଦିନ 2 ତାରିଖ ଦିନ. So 3/10/2023 status report ଟା ବି ମଗେଇ ଦେବେ ହେଲା. File be placed before register judicial. ଆଉ CDCA ତ reminder ଯିବ ସେ ତାନ ମଗେଇବେ. Notice sufficient କରୁଛନ୍ତି. All right. Yes, next case.
Item to mention my lord. Item 10 my lord.
Item 10 admit ହେଇଯାଇଛି ଆଉ bail ପାଇଁ trial court record ଆସିଲେ bail ବିଚାର ହବ. Deposition copy ଦେଇ ଦିଅନ୍ତୁ. Yes, next.
My lord, fix the date my lord.
ହଁ ଗୋଟେ week ପରେ ଆସିବ.
Item 15.
My name may be recorded now.
Yes, କାହାନ କୁହନ୍ତୁ କଣ?
Manoranjan Mudli.
Mr. Manoranjan Mudli, item number 10 ହେଲା. All right.
Obligation.
15. This is appeal under section 14A of SC/ST Act. S.K.SAHOO appearing for the informant.
Anand.
Allegation of 302.
The case diary.
Madam.
Mr. Tushar Kumar Mishra and his associate files power for the informant, which is taken on record.
May I pray one thing, madam?
Yeah.
The rejection order is of 29/4/2022. That is status report in the meantime.
କଣ ଅଛି status report? ଆରମ୍ଭ ହେଲାଣି trial.
Charge sheet ହେଇଛି. But trial super trial
2022 ରେ ଏପ୍ରିଲ ମସିହାର
ଆଜ୍ଞା.
ଆପଣଙ୍କର କଣ
trial ଆରମ୍ଭ
ଆରମ୍ଭ ହେଇନି?
ନାଇଁ।
ହେଇନି ଆଉ ସିଏ କହୁଛନ୍ତି ଆଉ
ଆଜ୍ଞା।
କାହିଁ ପୁଣି status report ମଗେଇବେ?
ଆଜ୍ଞା।
So this is item number 15.
15.
So CRLA 100/1116/2022. Okay. So date of custody?
Date of custody is my lord 17/6/21.
Charge sheet under section?
Charge sheet under section 302, 394, 323, 326, 307, 506 and section 31R and 32 of SC/ST Act.
31R?
32B
Okay.
of SC/ST Act.
Name of the deceased?
Name of the deceased is Ramesh Malik and one Babula was alleged to be the injured.
Ramesh Malik ala deceased.
Deceased.
Injured na ala?
Babula Malik.
Okay. Babula Malik statement padant.
I will draw your lordship.
File karchandi?
I have given all the statements. Page 54, one of the eyewitness.
Just
It is more a case of my lord exceeding right of private defense.
Code of 50?
54. He was an eyewitness.
Just a minute. 54 ଟା ଲେଖା ହେଇଛି ହାଡିବନ୍ଧୁ ମଲ୍ଲିକ.
Budhya Malik, my lord.
54 ଯାହା ମତେ ଦେଇଛନ୍ତି ସେଟା ହାଡିବନ୍ଧୁ ମଲ୍ଲିକ ଲେଖା ହେଇଛି. କୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଟା ପ୍ଲେସ କରିବାକୁ ଚାହୁଁଛନ୍ତି?
ମୋର ନାମ ବୁଦ୍ଧିଆ ମଲ୍ଲିକ.
ରୁହନ୍ତୁ ତାହେଲେ କୋଉ ପେଜ ରେ ସେଟା ଅଛି? ହଁ 51 ରେ ଅଛି. ହଁ ପଢନ୍ତୁ.
Let a copy be served upon that bail application.
Oh, ଦେଇନାହାନ୍ତି
No.
ଆପଣ
ମୁଁ
ଆଚ୍ଛା
ଖାଲି
ଅନୁମାନ appeal. Oh, give him a copy. We'll take up this matter on 21st. You just serve.
I will be sir.
ଆଚ୍ଛା ଏଇଟାକୁ ଗୋଟେ କାମ କରନ୍ତୁ so ଲେଖି ଦିଅନ୍ତୁ serve the let the land and council for the appellant serve the appeal memo along with the
All the what I've filed, I will give.
annexures to the land council for the informant during course of the delegate.
In this during course.
Matter be listed on 21st of all right. Yeah.
Supplementary.
Supplementary issue. एक क्वेश्चन एटा टिके आगे पढ़ देबे काम 2-3 छुट्टी अछि indicating the name of the land and council for the appellant sorry informant हला एटा कर देगी मु गला को रेडी कर देते अछि
Item 16.
Item 16, well, 3 SC estate and 302 is there.
I am
Other
appealing-
co-accused already released on bail.
I'm appearing on behalf of informant Milos.
ए दिले
No copy has been solved.
ने वकालतनामा अपन
Filed earlier filed.
all right the on a defect देखिजेंसी defect 9 कौन छरा वो good ground छरा the land council for the informant submits that he has not received the copy of the appeal memo along with the annexed document. Let the land council for the appellant supply the same to the land and council for the informant. अपन पाई जाइछन ये केस डायरी during আজি ଦେଇ ଦେବେ
ଆଜି ଦେଇଦେବି
ତାହେଲେ ନେବି ତାକୁ ଗୁରୁବାର ଦିନ ନଚେତ ରହିବ
ଗୁରୁବାର
ଓକେ ସେମ୍ ଅର୍ଡର କରିଦେବେ ହେଲା during course of the day ଆପଣ ନେଇଯିବେ କଲେକ୍ଟ କରିବେ ଗୁରୁବାର ସପ୍ଲିମେଣ୍ଟାରୀ ଆସିବ
ଆଜ୍ଞା
गुरुवार ଆସିବ
ହଁ 21/9/2023
ଆରଟା ବି ଗୁରୁବାର ଆସିବ ଯୋଉଟା ଆଗଟା
ଦିଟା ହଁ ଆଧିରେ ନେମ୍ ଅଫ ଦି ଇନଫର୍ମାଣ୍ଟ ଇଜ ଅଲରେଡି ଦେୟାର ତେଣୁ ସେଟା ଲେଖିବା ଦରକାର ନାହିଁ ହେଲା ଖାଲି କପି ଟୁ ବି ସପ୍ଲାଏଡ କର
Item 17.
May it please my lord. My lords, this is an appeal against conviction where the appellant is in custody since 19/9/2016 and I have been convicted. Your lordship may kindly have a glance to the operating portion, which is at page 38 is the hearing on the question of sentence, my lords.
what is that page?
Internal page 38, my briefs page is 61. Internal page 38 of the judgment and
Dushasana Kalu.
again.
So it is 304 part 1.
10 years, my lords.
अरे 8 आउट है जोटा स्लीप लगे रखी दियो एटा 15 नंबर रे ताऊ दे दो एटा आसीबो ना पुनी पहर दिन ए जे पहर दिन कोछि तो ना तो ऊपर लगे दो so this is item number 17 CRLA 330 2023 okay so 304 part 1 10 years fine of rupees 5,000 in default to undergo RI for 3 months, right?
3 months, my lords.
So, what is the name of the deceased?
My lords, the name of the deceased is Bisaya Kalo, who is related to the present appellant as the mother.
Bisaya Kalo, the mother of the appellant.
Again.
So, why the appellant killed his mother, or what is the motive behind why?
Well, the motive that has been brought out by the prosecution is that this present appellant was unhappy with the fact that his mother was always going to other houses for having food and everything, which he was reluctant, and that is for a reason behind that. For sudden provocation, he
Eyewitnesses are there.
My lords, there are three witnesses basing on whom the conviction has been raised. That is, PW1 is the informant, who is the brother of the appellant.
PW1 informant, yes.
PW15 is another witness, my lords.
Wife of the PW1.
Wife of the
Wife of
PW1.
PW1, okay.
And PW28, my lords.
Who is that?
That is another brother, my lords.
Independent with no, acha,
Brother, another brother. Rest all of them have turned hostile.
And how you assaulted according to the eyewitnesses to your mother?
By way of a wooden plank and a sickle.
Thereafter, I went to the house and forcibly brought my mother and go anybody not to talk on anybody except him and threatened that he could take food from anyone. Go to the house of anybody who would kill her like he had killed the previous wife. Holding a sickle, went to the back part of the house, caught some creepers. Thereafter, my brother returned to our house. After throwing creepers in the house, started quarreling with my mother by holding the said sickle. At that time, I, along with my wife, so and so, were present inside the heard everything. Thereafter, my mother went to the backside of their house and sat under a mango tree. Thereafter, the accused proceeded near my mother by holding the said sickle, severely quarreled with my mother. Then the accused assaulted 3 to 4 times on the head of my mother by means of a wooden plank of palastry, and as the result of which my mother fell down on the ground. Acha. Wooden plank, head 3 to 4 times. Okay. Oh, acha, acha. Again he assaulted. Then he pierced sickle on different parts of the body
of my mother, such as face, ear, leg.
Okay. This evidence is consistent in all the eyewitnesses' account.
Lords, the eyewitness number 15, she says like this. Lord, you may kindly have
No, come to the first. Let us see the doctor who conducted
Yes, my lords, PW26, my lords.
PW26 Varga.
My lords, may I please it?
PW26 kind. PW26.
Lords, I'm filing the copy.
Where is the PW26? Yes, okay. Got it. Lacerated wound, cross fracture of the temporal bone, so and so. On dissection, so and so are found intact. Dissection abdomen. Found fracture of shaft of left femur in the immediate all the above injuries to cause of proper injury to vital brain and hypothalamic shock. So, Mr. Das, where are the corresponding injury about that sickle assault, which your witness says, PW1? You see, again, we are reading it. PW1 about that sickle assault. I'm focused.
My lord, they holding this head sickle, my lord.
No. Sickle after.
Yes, ma'am.
You please, in the middle it is mentioned. Thereafter, the accused pierced the sickle on different parts of the body, such as face, ear, leg, and head. ଚାରିଟା ଜାଗାରେ ସିକଲ ପୁରେଇ ଦେଇଛି ମାନେ ପଙ୍କ୍ଚର ଉଣ୍ଡ ଟାଇପର ଆସିବା କଥା ଟୋଟାଲ କିଛି ନାହିଁ ଖାଲି ସେ ଉଡେନ ଫ୍ଲାଙ୍କ ର ଇଞ୍ଜୁରୀ ଗୁଡାକ ରହୁଛି sickle insertion जोटा बा piercing blows तार corresponding injury पाइलेनी PW 26 रो
lacerated खाली जा सकता है
lacerated that is corresponding to that wooden plank blow on the head.
no, that is one is in the right ear.
No, whatever it may be, all those are that wooden. That is why wooden plank was sent to him for the opinion, and the doctor
and the cause of injury also the death of my lord due to the head injury, my lord. So far the wooden plank, my lord, is concerned
that is there. Now this man was on bail during trial.
No, my lord.
Since when he is in custody?
My lord, he is in custody since the date
Judgment
of his custody from 19/9/2016.
Wait. 19/9/2016.
ଆଜ୍ଞା
ତାହେଲେ ଆପଣଙ୍କର
FIR
7 ବର୍ଷ ହେଇଗଲା।
8 ବର୍ଷ
8 ବର୍ଷ କେମିତି ହେଲା?
16 17 7 ବର୍ଷ 8 ମାସ। 7 ବର୍ଷ 8 ମାସ
କେମିତି ହେଲା?
16
7 ବର୍ଷ ବି ପୁରିନି ଏପର୍ଯ୍ୟନ୍ତ। 23 ପରା ଚାଲିଛି।
ଆଜ୍ଞା 23/9
19/9/2016।
ଆଜ୍ଞା
16/7 ତ 23 ଆଉ ଆଜି କଣ 19 ହେଲାଣି?
ନା
କାଲି 19 ହବ ଠିକ 7 ବର୍ଷ ହଉଛି।
ଆଜ୍ଞା
Yes, Mr. Das, heard the learned counsel for the petitioner, Mr. Sudipto Panda, learned counsel for the state, submits that out of 10 years of substantive sentence imposed on the petitioner for his conviction under Section 304, Part 1 of the Indian Penal Code, he has already undergone 7 years of sentence, and there is no chance of early hearing of the appeal in the near future. He placed the evidence of 3 eyewitnesses, that is PW1, the informant, who is the brother of the appellant, and PW15, the wife of PW1, and PW28, another brother of the appellant, and submitted that those 3 eyewitnesses, those stated that the appellant pierced sickle on different parts of the body of the deceased, but the doctor, bracketed PW26, who conducted post-mortem examination, has not found any corresponding injury, and therefore the eyewitnesses' evidence cannot be accepted in its entirety. The learned counsel further submits that there is no chance of early hearing of the appeal in the near future. Balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail and praise the evidence of PW26, the doctor. Considering the submission made by the learned counsel for the respective parties, the substantive sentence imposed by the learned trial court, period already undergone by the petitioner in judicial custody, nature of evidence adduced by the prosecution during trial, absence of any chance of early hearing of the appeal in the near future, I am inclined to release the petitioner on bail. He shall not indulge in any criminal activities, stay realization of fine.
I'm deeply obliged, my lord. May I pray for an urgent copy,
Yes,
my
yes.
lord? Grateful, my lord.
Item number 18.
Did you respond?
Challenge the cognizance order. The final form submitted, and it was
In final form, it was mentioned that no case was made out against the
This false
petitioner.
case, thereafter protest petition was filed by the informed, then cognizance is taken that.
Yes, my lords. Petitioner was the principal of the institution, and the informants are
You want
employed.
it next week or what?
Yes, my lords, next week.
All right. Mention is made on behalf of Mr. B.K. Sharma to adjourn the matter to next week. Place this matter in the week commencing from 25th September 2023.
Oblige, my lords.
Item number 21.
May I please use? Shimla, this is a SC/ST appeal for bail, my lord. The present petition was inside corporations, my lord, 86.
Just a minute. Hmm. 21
May I please use?
on SC/ST appeal.
For bail, my lord.
Notice
Melsa, not.
item number 21 CRLA 363/2023 notice sufficient. Kebe koile notice ta?
Not.
2023. Yes, what is the date?
Present petition on bail application, and he was taken into custody, my lord.
Where is that rejection order?
My lord, you are speaking annexed to my lord, page 21, my lord. Running page 21, my lord. And there complainant was appeared and she
Yes.
the complainant was appeared and she objected the bail application. That's why on the court below was raised to reject, my lord, the bail application, and also in the rejection copy in page 24, on the court below also observe in the middle portion, it transfers from the record the IO did not arrest the accused and release him in terms of section 41 CRPC. It is also mentioned, my lord, there, my lord.
And that is there. I have already gone through. Yes, Mr. Heard the Learned Counsel for the petitioner, appellant Learned Counsel for the state. The Learned Counsel for the state submitted that notice on the informant has been made sufficient since 9/8/2023. None appears for the informant. The Learned Counsel submits that during course of investigation, the appellant was served with notice under section 41A CRPC, and he complied with the terms and condition of such notice. And when he approached this court in an application under section 482 of CRPC by its CRLMC numbers 2167 of 2023, challenging the order of taking cognizance of taking cognizance, this court didn't incline to interfere with the same and directed the petitioner to surrender in the court below and to move an application for bail, and further directed the Learned Court below to take into account that 41A CRPC has been complied with during course of investigation. The Learned Counsel submits that charge sheet has been submitted under section 452, 354, 294, 323, 506, 509 of the Indian Penal Code and section 31RA and 32BA of the SC/ST POA Act. It is further argued that when the investigating officer didn't think it proper to arrest him and accordingly served notice under section 41A CRPC, and the petitioner and the appellant complied with the terms and condition of such notice, it was not proper on the part of the Learned Court below to reject the bail application. Further submits that petitioner has remained in custody for 3 months by now, and therefore the bail application may be favorably considered, and counsel for the state has no serious objection to the grant of bail. Considering the submission made by the land counsel for the respective parties, the nature of accusation against the petitioner, the fact that the petitioner has complied with the terms and conditions of the notice under section 41A of CRPC, and further taking into account the period of detention of the petitioner appellant in judicial custody, I am inclined to release the appellant on bail. Stop. He shall appear before the London trial court on each date when the case would be posted for trial, and shall not try to tamper with the evidence. Violation of any terms and condition shall entail cancellation of bail. Yes, next.
Item number 22.
May I please, Your Lordship?
Yeah.
The Lordship, on 8th August, I have supplied the copies of bail orders of co-accused persons. As per those orders, that was first disposed by Honorable Justice S.K. Mahapatra. That was CRLA number.
No, by this petition, this appellant or somebody else?
Somebody else, Your Lordship.
Because from that list it appears that 15 different applications have been filed at different point of time.
Yes, Your Lordship. Your Lordship
So,
also disposed one CRLMP where cognizance was challenged. Your Lordship directed
no,
to.
we are not. Question is that the bail application, whether it is disposed of by Justice Mahapatra, as you said, that was the first disposal, or prior to that?
No,
there is
that
any...
was that is the first disposal.
What is the number?
CRLA number 510 of 2020.
510.
Yes, Your Lordship.
2020.
Yes, Your Lordship.
And what is the date of disposal?
5/7/2022.
ତା ପୂର୍ବରୁ କିଛି ହେଇନି?
I have supplied the copy.
ତାପରେ ଦେଇଛନ୍ତି ଗୋଟେ 3/11 2022 ତାପରେ ଆଉ ଗୋଟେ ଜଷ୍ଟିସ ଅନରେବଲ ଜଷ୍ଟିସ S.S.MISHRA ଦେଇଛନ୍ତି 3/11 2022 CRL 671.
That was I have given.
କେମିତି କଣ ନା ଫାଙ୍କି କେବେ ଲେଖୁନାହାନ୍ତି କିଏ କୋଉ ଦିନ ଡିସପୋଜାଲ କଲେ କେମିତି ଜାଣିବ କଣ? ଏଟା
2022 କେସ୍।
ହଁ 2022 ଯେ
CRL
2021 ର ଆପ୍ଲିକେସନ ଗୁଡାକ ଅଛି, even if what the first application as it appears
2020 ମସିହା ଏଫଆଇଆର ହଉଛି 2020।
ହଁ ନାଇଁ ପ୍ରଥମ ଆପ୍ଲିକେସନ ଟା ଫାଇଲ ହେଇଛି CRL ନମ୍ବର 510 of 2020।
ସେଟା ହଉଛି ଜଷ୍ଟିସ ଅନରେବଲ ଜଷ୍ଟିସ A.K. Mahapatra।
ସେଇଟା
ହଁ
510 ଆଚ୍ଛା।
ଡିସପୋଜ ହେଲା 5/7 ରେ।
628 of 2020 ତାପରେ ଅଛି, ସେଇଟା କିଏ?
600
ଓହୋ ଏପଟେ ଲେଖା ହଉଛି ପୁରା। ଆଚ୍ଛା, ଡେଟ୍ ଅଫ ଡିସପୋଜାଲ ଟା କୋଉ ଲେଖା ହଉଛି? 5/7/2022।
Your Lordship also disposed one application, but the application this petitioner where cognizance was challenged. Your Lordship directed him to surrender, but that was after this date.
All right, ଲେଖନ୍ତୁ, the London Council for the appellant submits that the first bail application in connection with High Court PS case number 266 of 2020, out of which this criminal appeal arises, was disposed of by Honorable Justice A.K. Mahapatra in CRLA number 510 of 2020, as per order dated 5/7/2022. In view of se jo de debe konta se jo notice ta ache, list this matter before the assigned bench. Yes.
Grateful, Your Lordship.
Item number 23.
ଯାଇଥିଲା
ନା।
First time ଆସିଛି?
Yes.
ଆଉ କଣ state to produce case diary ଲେଖାହେଇଛି?
My lord, I have served copy, Your
Since
Lordship.
one of the offenses under yes, Mr. Tripathi,
Yes, ma'am.
31/7/2023 ରେ order ହେଇଥିଲା ଆପଣଙ୍କୁ extra copy ଦବା ପାଇଁ ଆଉ
କପି ଦେଇଛନ୍ତି ଆପଣ ତ ଅଛି ପରେ ଦେଇଛନ୍ତି ବୋଧେ ସେଟା ତ
My lord,
ଆଚ୍ଛା
notice.
I have served copy on
all right
1st August
yeah,
2020.
have you sent it or not?
No. That is not
Okay,
been
serve another copy. The learned counsel for the state, those petition appellant, those submitted that he has given a copy of the appeal memo along with all the annexures to the learned counsel for the state as per order dated 31/7/2023 for its service on the informant. Land counsel for the state on verification of the case record submits that it's not available with him, and the learned counsel for the appellant may serve another copy. Let the learned counsel for the appellant serve an extra copy of the appeal memo along with the all the annexures during course of the day.
Yes, Lord.
During
On next day, I have served.
It's all right during course of the day. Matter to be listed on the week commencing from Ajay case diary paijhan na nahi?
No.
And he has also not obtained the case diary and instruction about the criminal antecedent. List this matter in the week commencing from 3rd of October 2023.
My lord, in this
Yeah.
case, already 6 accused persons were released on bail. Case diary may be available, Your Lordship.
Give the number so that it
I
will
have
be
annexed or
verified.
release order for all the
Oh,
Your
bail
Lordship.
order kuda deyichanti.
My lord.
All right. The learned counsel for the appellant submits that since some of the accused persons approach this court for bail and they have been released on bail, the case diary might be available in those case records. Land counsel for the state may verify the same. Yes, next. Aji dei diyantu copy ta.
Item number 28.
20, I pray for a passover. Lord, notice was not solved.
মানে
Yeah, it was sent.
हाँ.
It was sent, but confirmation letter.
अच्छा confirmation letter. बाकी case diary पे ही
No,
regarding service and the matter may be taken off. Next week रखिबा ना कौन करूँ? Matter may be taken up next week. Leave this matter in the week commencing from 25th September 2023. Learned counsel for the state shall obtain written instruction about the service of notice on the informant. So also produce the case diary and obtain instruction about the criminal antecedent, if any, against the appellant. Yes, next.
Obliged.
Item number 29.
Same, Lord.
କୋଉଟା ମାନେ
29 ଟା
ଆଚ୍ଛା ଏଇଟା ଆଜି କପି ପାଇ ପଠେଇ
ହଁ,
ଦେଇଛନ୍ତି
copy ପାଇକି
ସେଇ
ପଠାଇ
ଟାଇପ ର ଅର୍ଡର କରିଦିଅନ୍ତୁ 25 ତାରିଖ ଦିନ ଆସିବ।
Item number 30.
May I please, Your Lordship, SC/ST appeal law.
Yes, Act.
Bail matter.
Yes, ma'am.
SC/ST bail. So notice has been issued.
No, the first time.
Oh, first time. Serve an extra copy.
Earlier it was rejected, my lord.
ଆଉ ଦେବେନି ନା କଣ କପି ଏକ୍ସଟ୍ରା କପି ଦେବେନି ଆଉ ଥରେ ରିଜେକ୍ଟ ହେଇଛି ମାନେ ଆଉ ଦେବେନି କି ଦ୍ୱିତୀୟ ଥର ଫାଇଲ କଲେ ହଁ ନା ଥରେ ଦେଇଦେଲେ ଯେତେଥର ଫାଇଲ କରୁଥିବେ ଆଉ ନୋଟିସ ଯିବା ଦରକାର ନାହିଁ ଇନଫର୍ମାଣ୍ଟ ଦି କେସ୍ ଇଜ ଅଣ୍ଡର 3 SC/ST Act notice is required to be issued. Okay, serve an extra copy notice to be issued. Matter to be listed in the week commencing from 3rd October 2023.
Item 34.
May I present?
Hmm.
File interim bail application ballot 1132, and we have also filed the surrender certificate as well as the custody certificate. 8 years have already been languished in custody.
What is the offense here?
Offense, my lord, 365.
What is the sentence imposed?
20 years. 20 years, my lord.
So, you are granted interim bail once.
2-3 times. You can see.
And you surrender at right time.
Yes, sir.
But how many years you have already undergone?
Approximately 8 years.
Have you got the custody certificate?
No, I have already filed. I
Huh?
have given already.
Achhi apan bare.
Yes, sir.
Diyon.
Already served. Already filed.
Annexure C hauchi 3 custody certificate.
Yes, sir.
Okay, senior superintendent circle jail has signed it.
Yes.
Name of the accused hala Baba alias Suru. Okay, this man.
Suru Babu. Ujjwal Kumar Nath.
Total code lekha hai.
Total to nahi. Total nahi.
कौन हिसाब करिवे ना कौन कुआड़ कौन केतବେଳେ ଯାଇଥିବ ତାର କେତେ ଥର ସିଏ ବେଲ ରେ ଯାଇଛି ତାର ଗୋଟେ ହୁଏ ପରା ସେମାନେ ଟୋଟାଲ ନେଇକି ନା ଆସନ୍ତି
3 ଥର ସାରେ ଯାଇଛନ୍ତି ଇଣ୍ଟିମ ବେଲ ରେ
ଆପଣ ନେଇ ଆସନ୍ତୁ ଗୋଟେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ the Learned Council for the state seeks some time to produce the custody certificate.
Yes.
The Learned Council for the appellant submits that during pendency of this criminal appeal, the appellant has been released on bail, interim bail, thrice, na?
Yes.
And each time after availing the interim bail period, he surrendered at right time. Let a report be called for from the Lennon trial court in that respect. Free copy of the order be handed over to the Lennon Council for the state. Matter be listed in the week commencing from 3rd October 2023. Yes.
The medical medical wife of the appellant is in the serious malord. That's why I'm filing interim bail.
No, if you have already undergone 8 years, let us see that both these things.
Yes.
Acha, 8 abhi obtain kar diyon to say jo IA ra, that is IA number 1132 of 23.
Yes. IA number 1132 of 23.
The Learned Council for the state shall also obtain instruction on the interim application filed by the appellant by IA number 1132 of 2023 on the ground of ailment of the wife of the appellant. Mr. Tripathi?
I have already obtained.
Obtained?
Yes.
All right. This is the next date. Okay.
Item number 35.
And the transport brief, madam, she begins on my lap. Yesterday, you are receiving the bill.
The brief has been transferred to Mr. Bigyan Sharma.
On behalf of
Has he filed the wakalat now? Okay. The mention is made on behalf of Mr. B.K. Sharma that the brief has been transferred to him, and he has also filed the wakalatnama, which is taken on record. The Learned Council prays for an adjournment. এটা কোন SCR letter?
OPD case challenge Miller, Charles Miller.
Okay.
Dated 31/3/17.
The ତା ଭିତରେ କିଛି development ହେଇନି କଣ?
Last of the minor directed to start call for a status report.
ଆସି ଯାଇଛି?
ନାଇଁ minor directed to obtain status report.
All right. Status report ମଗା ହେଇଥିଲା ନା ମଗା
ଆଜ୍ଞା ମଗା ହେଇଥିଲା ନା 1/8/23 ରେ
Flag K Miller.
flag K ଏ ବାହାର କର କଣ flag K କହୁଛନ୍ତି? नहीं flag K कहीं एडा रखो एक flag K सबस last करना थी बोले जेरोस करना थी this case arises out of so and so charge sheet summons been issued on 12/7/2022 ରେ ଗୋଟେ order ହେଇଥିଲା for 4 weeks adjournment तापर आउ किसी order ହେଇନି ସେ ତାର ଗଲା adjournment ଦେଇ ଚାଲିଛନ୍ତି period the status report submitted by the Learned Trial Court dated 8/8/2023 from which it reveals that since certified copy of the order dated 12/7/2022 of this court was produced before the Learned Trial Court, in which it was directed to adjourn the case for a period of 4 weeks. It seems that the Learned Trial Court has not taken up the case further. When that 4 weeks period is already over and no further order has been passed by this court extending the order which was passed on 12/7/2022, the Learned Trial Court should have proceeded further. It is expected that the Learned Trial Court shall proceed with the case in accordance with law, in as much as there is no stay order operating at present. The matter to be listed in the week commencing from such and such date. The names of Mr. Himanshu Shekhar Mishra, T.K. Nayak, R. Das, and A.K. Mishra shall not be reflected in the cause list henceforth, and in its place, the names of se jo aji uta wakalatnama file kale. Wakalatnama ta kaun era? Achi to niyan.
Item number 36.
May I please, Your Lordship?
Yes.
But petitioner is in custody, my lord. Since that on 30/6/2015 last order, last time Your Lordship has granted interim bail 9/3/2023. Kindly have a glance to the order, my lord. 9/3/2023 order.
Yes, you are granted interim bail for
3 months.
3 months.
Kindly surrender करिए, surrender certificate दे दीजिए.
What do you want now?
ରହିଲାଣି କଷ୍ଟଡିରେ ମାନେ more than total ହିସାବ କଲେ 8 ବର୍ଷ 2 ମାସ दुई थर इंटरिम बेल जाके दुई थर टाइमली सरेंडर कर
What is the sentence imposed?
10 वर्ष
10 years.
आज्ञा
So what is the custody certificate?
कस्टडी सर्टिफिकेट कर लास्ट
Mr.
in the order it is mentioned
Say you
in the order it is mentioned
no
Your
order
Lordship.
name custody certificate देखियो ना केते actually land. ये sole appellant.
ना आउरी अदर कोई किस
नहीं
अदर
नहीं यही appeal.
आज्ञा आज्ञा 16 एप्रिल
ଏମାନଙ୍କର ମଗା ହେଇଥିଲା କି ଯାହା ସହିତ କନେକ୍ଟେଡ ଆପିଲ ଗୁଡାକ ଅଛି
कनेक्टेड
ତ୍ରିପାଠୀ
Yes, my lord.
ଏଥିରେ
Custody certificate ମଗା ହେଇନି।
ନାଇଁ ଏ ଚାରିଟା ଯାକ କ୍ରିମିନାଲ ଆପିଲ ରେ ବେଲ ଆପ୍ଲିକେସନ ତିନିଟାରେ ବୋଧେ ନାଇଁ ଦିଟାରେ ଫାଇଲ ହେଇଛି ସେ ଯାହା ବି ହଉ ଗୋଟେ ନେଇ ଆସନ୍ତୁ ଏମାନଙ୍କର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଗୁଡାକ
Yes.
so how many person face trial 4
आज्ञा
ଚାରି ଜଣ ଯାକ ଚାରିଟା କ୍ରିମିନାଲ ଆପିଲ ଫାଇଲ କରିଛନ୍ତି
सेपरेट आज्ञा
alright ଲେଖନ୍ତୁ IN number ପ୍ରଥମଟାରେ ଅର୍ଡରଟା କରିଦିଅନ୍ତୁ IN number 1710 of 2023 this is an application for interim bail
ना
bail
बेल आज्ञा
the London Council for the appellant submits that out of 10 years of sentence imposed by the London trial court, the petitioner has undergone about 7 years of
ना
sentence.
सर 8 वर्ष ऊपर
Acha, more than 8 years. More than 8 years.
2015 ରୁ କଷ୍ଟଡି
The Land Council for the state wants to obtain the custody certificate of not only the appellant Sadhava Meher, but also the appellants in the connected criminal appeals, that is Suru Kahar, Kumar Mani Kahar, and Narottam Prusti, who faced trial along with the appellant and were also found guilty under section 20B2C of the NDPS Act, and same punishment was imposed on all the four. List this matter in the week commencing from 3rd of October 2023. Free copy of the order be handed over to the London Council for the state.
Who is jail?
Jail, who jail lo achandi ki?
ବହୁତ ଜେଲ
Both jail
ବହୁତ ଜେଲ
from the superintendent of both jail. All right.
ଖାଲି 25 आर्म्स एक्ट भी अच्छी थ्रेड कन्विक्शन रे
अच्छा 20B2C
ଆଉ 25 आर्म्स एक्ट ଛାଡି ଦେଇଛ 3 ବର୍ଷ ହେଇଛି ସେଥିରେ
हाँ
ରନିଂ ପେଜ 51
ए
20B2C
ठीक है
chapter
ठीक है रोन रोन देखते हैं concurrent sentence तो
ଆଜ୍ଞା concurrent sentence
अच्छा 20B2C रहुची 10 years ଆଉ Arms Act 25 रहिची देखिले 3 years कौन कहउछन and concurrent sentence है ना हाँ right that is at page 47 running page 31 होची internal page देखिले yes next
Item 37.
My lord, I am in item 37. I am item second item, my lord.
My lord, I am
I may
first
begin, my lord, in virtual mode.
एवढाक एका संगरे आसीबो ସମସ୍ତଙ୍କର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ମଗା ହବ ମଗା ହେଇଛି 3 ତାରିଖ ଦିନ ଆସିବ ଏଇ ଯୋଉ 36 ରେ ଟୋଟାଲ 4ଟା ଯାକ ମ୍ୟାଟର 3 ତାରିଖ ଦିନ ଆସିବ yes item 37
My lord, item number 37, my lord. I am for the first item. Last week, my lord, honorable court directed the state council to verify surety.
First item माने कौन गोटे तो item अछि
हाँ गोटे item अछि से कहउछन second item तार कोन अछि
second
In
item माने
second item, my lord, I am in criminal appeal number 613/2017. In this case, my lord, appellant is in custody for near about 8 years, my lord. I have filed an IA. It is pending, my lord. I had make a mention, but it not listed, my lord. That is from next week.
What is that IA number?
IA number, my lord. IA number 2143 of 2023.
2143 of 2020.
2143 of 2023. CRL number 613/2017.
21 तो
my lord.
2143 of 2113 तो 43 तो
आगे
Yes, 2143 23.
Okay. So now
more than 7 years to near about 8 years, my lord. He is in custody.
just a minute. 596 रे कौन
Order ହେଇଥିଲା
last order होची 27/6/23 ना आउ तापर order होची
नहीं
हां
सिक्योरिटी वेरिफिकेशन ପାଇଁ ଥିଲା सिक्योरिटी वेरिफिकेशन ପାଇଁ କହିଥିଲେ
24/7 कौन ହେଇଥିଲା कौन order ହେଇଛି कौन तुम अधा करछो अधा कराउनी आज 27 ପରେ ଆଉ ଗୋଟେ order ହେଇଛି ତାକୁ ନାହିଁ
24/7
ନେଇଲେ
ହଁ ଆଜ୍ଞା
କଣ ହେଲା
24/7 ଆସିଛି
ରିପୋର୍ଟ ଟା ଦିଅ ଏଟା କଣ ଲେଖା ହେଇଛି କଣ ଲେଖିଛନ୍ତି ପଢନ୍ତୁ ତାକୁ କଣ ହିନ୍ଦୀ ଫିନ୍ଦୀରେ ଲେଖିଛନ୍ତି ତ हिंदी ना उर्दू ये रखू तो ठीक
फास्ट हिंदी टा होची एड्रेस वेरिफिकेशन इट इज ट्रू एंड देयर इज नो सीए
उक्त स्वांशो सत्य प्रकाश उर्फ बाबू
यस
की आपराधिक इतिहास हेतु थाना अभिलेखा का स्वांशो चेक किया उसके विरुद्ध प्रासंगिक कांड का
अन्य कोई कांड दर्ज नहीं
अच्छा तो माने आउ नो सीए राइट आउ सिक्योरिटी विषय कौन लिखला सिक्योरिटी तो अपन लोकल रु आनिबे ना
हां लोकल देइछि म आज्ञा कोड डायरेक्शन कला म इमीडिएट देइछि
regarding verification of the swans willingness of the swans family members I personally contact with the sureties Ravi Narayana Sandha son of Swanso on verification he is produced one ROR Swanso found that ROR is genuine and issued in the name of Swanso of village with the mother of Swanso and contact with the sureties Paramesh
पर सेठी
त्रिपाठी सेठी
आज्ञा
हाँ अच्छा से जो पट्टाटा तो ता मा ना रे अछि आ आपण ता ना कोन दी दिछनी
ता मान तार पट्टा चेंज हेनी तार मानार प्रथम रु अछि से ता
मा बंची कि ना नाही
अछंती
अछि ना
ना मा नांती मा नांती से ऑलरेडी या पूर्व गोटे बेल भी नेइछि आज्ञा गोटे सेई इयर गोटे बेल नेइछि सेई पट्टारे गोटे जन एडी जे बहुत रु गोटे बेल नेइछि माइल
से केमती नला मु जानिनी मु जानियो चाहूची आपण यादे रिपोर्ट आसिला जे ए जो पट्टाटा आपण देइछंती सेटा आपणकर मा सुधावाणी संढनारे रहिछि तो आपण मा जदी जीवित थिबो ताले आपण केमती सेई पट्टा बेसिस रे
जीवित नाही जीवित नाही माइलड एटा गोटे
एटु की जणा पुनी
माइलड एटा गोटे देखंतु एटा गोटे एडीजे रे बहुत रु सेई पट्टारे नेइछंती
सेतल जणा पड़छि कि नाही कि आरटा होची कोन परमे सेठी
यस
son of Swanso
संकीर्तन सेठी
on verification it is found that ROR khata number of Swanso and found that the ROR is genuine which stands in the name of Sankirtan
सेठी बापा दारो
Sethi
लेट
son of Swanso he is the father of Swanso this surety is agreeable to Swanso ये संकीर्तन सेठी भी डेड
आज्ञा
कौन आपनर कौन इंस्ट्रक्शन अछि तार जनकर माँ जनकर बापा ना रे संपत्ति अछि से माने बंची जंती ना नहीं
They will say better. They will file an affidavit. So that it will.
ऑलराइट नहीं तांको इंस्ट्रक्शन होची मरि जाइछंती बट मरिवार तो किसी डॉक्यूमेंट दउ नांती बेटर इंस्ट्रक्शन नहीं जानतो काई तो गड़ेवा लिखि दम द लैंड काउंसिल फॉर द स्टेट as per the order dated 24/7/2023 produced written instruction received from Birsan Nagar police station এটা কোন লেখা আছে সিংহভূমি
Singhbhum. Purba Singhbhum.
हाँ
Virasnagar.
हाँ पूर्व सिंहभूमि Jamshedpur Jharkhand to the effect that there is no criminal antecedent against the appellant. And he has also produced a written instruction received from OIC Bausuni police station that the ROR submitted by the Learning Council for the appellant are genuine and both the sureties, namely Ravi Narayan Sandho and Parame Sethi, were ready to take the petitioner appellant person on bail. However, it is mentioned that so far as local surety Ravi Narayan Sandha is concerned, the ROR stands in the name of Sudhavani Sandha.
Sadhavani, sir.
Sadhavani Sandha,
Yes.
His mother. And so far as local surety Parame Sethi,
Sankirtan Sethi ta bapa.
no, Parame Sethi is concerned, the ROR stands in the name of name of his father, Sankirtan Sethi. The London Council submitted that Sadhavani Sethi as well as Sankirtan Sethi are dead.
Yes.
Since the London Council is not producing any death certificate of the aforesaid two persons, let the London Council for the state obtain instruction in that respect, matter to be listed in the week commencing from 3rd October 2023. Written instructions are taken on record. Yes.
মানে supplementary আছে উকিল র পড় নাই supplementary আছে
My lord, my matter may be taken up next week.
4/10/2023. अच्छा এইটা जो लिखिबे CRLA number 613 of 2017 लिखि दियंतु hard miss Vijay Lakshmi Tripathi, London Council for the appellant. She submitted that one interim application by IA number 2143 of 2023 has been filed for bail. List this matter along with CRLA number 596 of 2017 along with IA number 2143 of 2023 on 4/10/2023. Yes.
Obligation.
Item number 38.
Lords, Lordship, I am through hybrid mode.
Okay.
Yes. Lordship, I am in JC since 25/10/2017. The impugned order is of dated 29/2018, and I was on the interim bail for 3 months only, Lordship. So if we see the timing, it's almost 5 years and 9 months, and the amount of contraband is 21.
No, you are now on interim bail.
No, I was on interim bail earlier, last year for 3 months, and I surrendered on the time, Lordship. And the amount of contraband is
No, just a minute. Let me see.
In this case, paper book is ready.
Paper book is ready.
Yes.
All right. It's a 2018 appeal.
Yes, Lordship.
So, no, I just want to know that how many appellants are there in this criminal appeal?
There is only one.
One.
Only one, Lordship.
Let me verify.
He is the sole appellant.
But how many interim applications are pending for
Lordship,
bail?
I have filed in this year. We have filed IA number 1807/23 for bail and suspension of sentence.
You see, one application is pending for stay of realization of fine.
Yes,
Another is for extension of interim. Obviously, that is become infructuous because you have
Yes,
already surrendered.
Yes, Lordship.
So, one IN number 1326 of 2021. This is an application for extension of interim bail. Since the petitioner appellant has already surrendered, this interim application has become infructuous and accordingly disposed of. Next, there is apart from that, there is one interim bail application, one bail application, then another is IA for suspension of sentence and bail. So 3 bail applications are pending. One is interim bail, the other 2 are bail applications.
Lordship,
So,
I have filed the application bail for the regular bail 1807/21. I want to pursue this application.
1807.
07/23.
IN number 94 of 2022 and IN number 2260 of 2022. IN number 94 is for interim bail, and the second one, that is 2260 of 2022, is for bail. Mr. Sham Manohar, Learned Counsel, appearing for the appellant, doesn't want to praise this application, and accordingly, these two, IA 94 2022 and 2260 2022, are disposed of. Now, so far as IA number 1807 of 2023, what is your submission? Out of 10 years, you have already undergone 5 years.
5 years, 9 months. 9 months till now.
You have got the custody certificate with you.
That has not.
But see, one very important relevant thing is the amount of contraband. 21 kg, 50 gram. So even a slight error in weighing can bring this case from commercial to medium quantity.
No, it is a slight error. It is 1 kg and 50 grams above.
Yes,
not that it's a slight error. So that is a matter. Let me first obtain about the instruction about the detention period.
Yes,
that the Learned Counsel submitted, that he has instruction that out of 10 years of substantive sentence imposed by the Learned Trial Court, the appellant has already undergone 5 years and 9 months of sentence.
8 or 9.
Learned Counsel for the state seeks some time to produce the custody certificate. List this matter in the week commencing from 3rd October 2023.
No, which jail, my lord?
Lordship, pray for any listing in
Can
the
you tell Mr. Manohar in which jail the appellant is there?
Koraput jail.
Koraput jail. Submits that in Koraput jail is there. So,
miscellaneous list, Lordship, may it be taken in the family condition is very, very worse, Lordship.
Okay. Say, and how many times you have gone on interim bail?
Yes, Lordship, just one time.
Once. Okay, all right. So it will come on 3rd October 2023. Yes, next.
And other names be deleted from the cause list and from the title.
Okay, your name will remain and any
Yes, Lordship.
other name you want to.
Yes, Lordship. Earlier advocate's name.
Okay, except the name of Mr. Sam Manohar, the name of other learned counsel shall not be reflected in the cause list henceforth. Yes. Yes, next.
Item 40.
May it please your lordship. When the petitioner was earlier released on interim bail, my lord, petitioner has surrendered. I have filed an IA for bail, and along with the IA, I have attached the surrender certificate, my lord. But IA
No, now it is the case of appeal of sole appellant.
Sole appellant, my lord.
But 2 bail applications are pending. 1 interim bail application is pending. Which one you want to press?
Bail application, my lord. 1808.
1808. Other you don't want to press. All right. Lekhantu, IN number 819 of 2023. This is an application for bail. Land Council doesn't want to press this application disposed of. Similarly, IN number 973 of 2021. It's an application for interim bail. Doesn't want to press. Not pressed. Now the only bail application remains is 1808 of 23. Right? So what is the
Paper book
conviction?
ready, my lord.
Paper book ready. What is the sentence imposed and how many years you have stayed?
Sentence imposed was for 10 years, my lord. And
Okay, let us see that operative part. Judgment বার করুন তো।
Having regard to the submission movement and the nature and gravity of offense, I sentence the convict to undergo RI for 10 years and to pay fine of rupees 1 lakh only. In default, further to undergo RI for 1 year.
So ଆପଣଙ୍କର କେତେ ବର୍ଷ ହେଲାଣି?
5 ବର୍ଷ 8 ମାସ ଉପରେ ରହିସାରିଛି।
ଜମା ଯାଇନାହାନ୍ତି interim bail ରେ?
ଯାଇଛୁ, my lord. And on the last occasion, lordship had granted bail, and before that, twice I have been granted interim bail.
Custody certificate ଅଛି?
ନା
ମଗେଇ ଦିଅନ୍ତୁ। The Land Council କରିଦେବେ ତ? ସେଇ 2 ତାରିଖରେ 3 ତାରିଖରେ ଆସିବ। Custody certificate କୋଉ ଜେଲରେ ଅଛି?
ଜଗତସିଂହପୁର।
ଜଗତସିଂହପୁର ଲେଖି ନିଅନ୍ତୁ। Custody certificate 3/10/2023. Yes.
Item 41.
Order dated 6/8/23. I'm already surrendered.
Surrender certificate, Land Council files surrender certificate.
Lordship, IN number 1681 on infractuation. IN number 1681/2023 infractuation.
କିନ୍ତୁ କିଛି ଲିଷ୍ଟରେ ନାହିଁ।
Extension of
କେତେ
time.
ନମ୍ବର? 41. Acha. IN number 1681 of 2023. This is an application for extension of time. Since the appellant has already surrendered, it has become infructuous and accordingly disposed of.
Press bell application.
Okay. Next. Mr. Sambit Mahanti. Yes, Mr. Nando.
Yes, my lord, I have given ROR copies along with other documents for verification. Last
बाहर लोको
हाँ sir.
Udiar.
Bihar.
Verify कर देले. Security document गुड़ा ଦେଇଛନ୍ତି?
Sir.
तो address verification कौन आसिला और security documents कौन आसिला?
address verification ଟା ଆସୁନି address verification ଆସୁନି 5ଟା letter ଗଲାଣି
ଆଉ ଇଏ ଯୋଉ ସିକ୍ୟୁରିଟି
security ଆସିଛି
କଣ ହେଲା? ସିକ୍ୟୁରିଟି ର ୱିଲିଂନେସ୍ ଆଉ ସିକ୍ୟୁରିଟି ର ଡକ୍ୟୁମେଣ୍ଟ
ଲୋକନାଥ ପ୍ରଧାନର security verify ସିଏ ବି verify ହେଇଛି ଦିଟାକ ଠିକ ଅଛି
ଲୋକନାଥ କଣ
ପ୍ରଧାନ
ହଁ ଆଉ ଗୋଟେ ଦିଟା ସିକ୍ୟୁରିଟି ଥିବ ନା
ଇଏ ହଉଛି ଆରଟା ଟିକେ ବଡ ବଜାର ପିଏସ୍ ସେତେ ରେସ୍ପଣ୍ଡ କରୁନାହାନ୍ତି କିଛି ବଡ ବଜାର
ଖାଲି ଗୋଟେ କର ଭେରିଫାଇ ହେଇଛି
ହଁ
ଲୋକନାଥ ପ୍ରଧାନ
ୟେସ୍
ଆରଟାର ନାଁ କଣ?
ବଳରାମ ସାହୁ ଯାଇଛି ସେ
ଓକେ ସେଇଟା yet to be verified
yet
right
to be verified
ଆଉ ଏଇଟା କଣ କହୁଛନ୍ତି ଆଡ୍ରେସ ଭେରିଫିକେସନ ନୋ ରେସ୍ପନ୍ସ
no response 5ଟା ଗଲାଣି କିଛି କରୁନି
କିଏ ପଠଉଛି କାହା ପାଖକୁ
SHO ପାଖକୁ ପଠା ହଉଛି
କୋଉ ଜିଲ୍ଲାର କୋଉ ଷ୍ଟେଟ ର
SHO ହାସାନପୁର डिस्ट्रिक्ट समस्तीपुर बिहार
ହାସାନପୁର ତାପରେ କଣ
डिस्ट्रिक्ट समस्तीपुर यस
बिहार
डिस्ट्रिक्ट बेगूसराय
ask the secretary or he has already assured this court to look into this matter. You said 5 letters, na?
Yes, ma'am.
5 letters have been sent. The Land and Council for the state submitted that after receiving the names, address, and documents of 2 local sureties, namely Loknath Pradhan and Balram Sahu, instruction has been sought for, and he has received the instruction that local surety Loknath Pradhan is ready and willing to take the petitioner on bail, and the documents filed by the documents of the said surety are genuine. However, so far as local surety Balaram Sahu is concerned, the instruction is still awaited and he may be given some time. Subpara kar diyantu. Land Council for the state submitted that as per the order of this court to verify the correctness of the address of the appellant furnished in the cause title, letters have been issued by kiye pathuchi apanakar chithi
IIC Golanthara PS
IIC Golanthara PS is making communication with the SHO Hasanpur in the district of Samastipur in the state of Bihar
by wireless message
wireless message and also by registered post letters, and even though 5 times communication has been made but there is no response from the other side, let the Superintendent of Police of Ganjam, Berhampur make necessary communication with the Superintendent of Police of which district it is? एटा कि कहार बेल एप्लिकेशन आपण देइचंदी
नंदन राम
नंदन राम
नंदन राम LS करण
ओके Superintendent of Police Samastipur in the state of Bihar to ascertain whether the address of the appellant number 1, Nandaram alias Karan, furnished in the cause title is correct or not. The instruction be obtained by the next date, which is fixed to 3rd of October 2023. A free copy of the order be handed over to the Learned Council for the state for compliance. Yes. P10 2023. बाकी तो लॉन्च करे नबा
I may pardon to mention, my lord, item 310, it is a fresh addition matter, but it has been wrongly listed under orders, my lord. So next week, asu on 25th.
310 Tabarkar. You are convicted under section 307.
My lord, and sentenced to order to arrive for 4 years, my lord.
You were on bail during trial.
My lord.
Right hard admit. Call for the trial court report. He was on bail, bail allowed. Stay realization of fine.
Oblige me.
Item number 267.
Yes. What is this matter?
My lord,
What do you want?
interim bail.
Which 704?
704, my lord.
Which application you have filed for interim bail?
IA number, my lord, 2125 or 2023.
Nice application. Okay. So, mention that her parents, father, mother, and one sister are taking his care since the beginning of her pregnancy.
He's the only male member, my lord, the appellant. His father is expired and only mother is staying at home.
No, the girl is now staying with her parents, not at your house.
Because nobody is there, my lord. At second child, my lord, surgery may be required, my lord. Presence of advent.
IA number 2125 of 2023. This is an application for interim bail filed by the appellant on the ground that the wife of the petitioner is pregnant and her expected delivery date is within 10/9/2023. The learned counsel for some medical documents have been annexed to the interim application. The learned counsel for the state has obtained written instruction dated 12/9/2023 from Inspector in charge of Patapur Police Station, Ganjam, from which it appears that during verification it was ascertained that the wife of the petitioner is in pregnancy state and living with her parents and family members in village Dengao Sta. Along with the application and the written instruction received by the Land Council for the state, I am inclined to release the petitioner for interim bail for 1 month. While on interim bail, the petitioner shall not indulge in any criminal activities. And the matter to be listed on such and such date, the Land Council for the petitioner shall file the surrender certificate. Yes, next. IA, that is 2125 of 2023 is disposed of.
Item number 44.
Babita Sahu, Sushant Kumar Tripathi.
Surrender certificate not filed.
Okay, pass over करूँ तो देखिए.
Item number 45.
Lord, I am filing surrender certificate. May be accepted.
The Land Council for the appellant files the surrender certificate which is taken on record. Yes, next.
I believe, Lord, I have filed another IA, may be taken up along with that IA.
What is the number?
2247 of 2023.
Land Council for the appellant submits that another interim application for bail has been filed by IA number 2247 of 2023. Copy of the same has been served on the
Already.
Copy of this interim application has been served on the Land Council for the state. List this matter in the week commencing from 3rd October 2023 along with IA number 2247 of 2023. Land Council for the state shall obtain instruction on the interim application.
Item number 46.
46 on behalf of Mr. Gopal Agarwal, kindly pass over for the day, my lord.
Okay, mention is made on behalf of Mr. Gopal Agrawal to adjourn the matter. Mr. J.P. Pathal and Special Counsel appearing for the OPID Act is present. As prayed for, list this matter in the week commencing from 25th September 2023.
Against acquittal, my lord. Here, my lord.
What is the offense?
Offense 307, along with other offenses, there is a injured. PW2 has categorically stated that the accused person has brutally assaulted by means of my lord, Porshram Tangia, as a result of which he sustained injuries, and the corresponding injuries also by the doctor PW1, PW11, my lord. And another thing, my lord, PW, some witnesses, PW3 and PW4, they are also stated that they are, my lord, while the appellant was in front of the house, that the accused person assaulted, my lord. And that, but the learned.
No, you come to the page number 10, internal page 10, paragraph number 15. Please read it out.
Judgment or parapet.
Yes, my lord. In this case on hand, the oral evidence produced by the prosecution adhere to the prosecution theory of assault by Porsuram Tangia. On the other hand, the medical evidence shows assault by a blunt object, my lord. Porsuram Tangia is not a blunt object, but a sharp cutting weapon. Hence, it can be inferred that oral evidence regarding assault by Porsuram Tangia is not truthful. So I have just categorically stated that his investigation reveals the cause of dispute is the landed property. In such situation, false implication of the accused to the alleged injury cannot be ruled out. Moreover, IO has not seized any weapon of the offense in this case. The place of occurrence has been stated differently by different witnesses. On one hand, IO stated that place of incident is in front of house of Ramachandra Naik, PW7. Ramachandra Naik has also stated that the place of occurrence is in front of the house. On the other hand, the victim and other witness have stated that the place of occurrence is a road running in front of the house of the victim. But in this case, my lord, the occurrence took place. There is, my lord, they have stated that the Learned Court will have said the weapon of offense has not, my lord, seized, and the place of occurrence, one is saying, my lord, in front of a house, one is say that he was running in the road. But the incident took place, and there is a, my lord, injured has categorically stated, and PW3 and 4, they have stated that this, my lord, the accused person was running and assaulted to the, my lord, injured person. But on this ground, they have stated.
First, how do you say that when your injured says that I was assaulted by means of a tangia, and obviously it is a sharp cutting weapon. He has not stated that blunt side of the sharp cutting weapon was
that is what
had it been that statement, matter would have been different. But you are your witness is telling that a sharp cutting weapon has been used. If the sharp cutting weapon is used, then ordinarily it is expected that cut injury or incised wound would be found. But the medical evidence shows that the injury was caused by a blunt object. So you have to, as a prosecution, you have to clarify. Otherwise, the oral evidence runs contrary to the medical evidence. And if on that one of that ground, the order of acquittal has been passed, can it be said that it is perverse or anything, any illegality has been committed?
But
This is one of the reasons, and many cases on this ground itself, acquittal orders have been passed. When the medical evidence, you see, there are cases where the oral evidence is of such a nature, is of such truthful or cogent clear, that even minor variation with the medical evidence, no importance is given. That is the law. But if it completely nullify the oral evidence, that means if the doctor says that this is a injury which can be caused by blunt object which we ordinarily say that it is a lathi or something like that. But your case is that the kaun se nada Tangia, Parsuram Tangia was used. So how do you correlate it? There is also previous dispute, land dispute is there.
My doctor is saying one lacerated wound, 4 inch, 1 inch over right frontal parietal region.
Have you brought out any clarification from the doctor? Sir, look, this tangia can also cause such injury.
You find that injuries are grievous in nature might have been caused by blunt object.
No, when the doctor says in the chief examination that it is caused by
evidence doctor.
No, it is recorded there. When the doctor says that it has been caused by blunt object, and the prosecutor knows that the evidence is that a sharp cutting weapon has been used, so he should have at least put a question, or initially should have ascertained that doctor, here is a case where sharp cutting weapon has been used, that is the version of the injured, and you have mentioned that the injury can be caused by blunt object. So how can the prosecution correlate it? Is a fair prosecutor. So you should have brought the truth before the court. Otherwise, doubt is created that whether that Parsuram Tangia has been used at all or not, because that Tangia was not seized by the investigating officer. And once it is not seized, there was no scope for producing the same before the doctor for obtaining the opinion. That might have been deliberately done. Had it been seized and it would have been sent to that doctor, he would have negated that no, with this weapon the injury is not possible. That would have weakened your case. That is why you deliberately did not seize that weapon and did not sought for the opinion of the doctor.
But my lord, the injured has categorically stated.
Injured କହିଦେଲେ କ'ଣ ସେଟା ତାର ହେଇଥିଲା ମାନେ ଯୋଉ ଭଗବତ ଗୀତା ନା ବେଦର ବାଣୀ, ସେ ଯାହା କହିବ ତାକୁ accept କରିବ.
Other witnesses have also stated regarding the assault part.
All right, this criminal appeal has been filed by the appellant Sankarshan Gowda under section 372 of CRPC, challenging the judgment and order dated 21/11/2018 passed by the London Session Judge Chhatrapur Ganjam in ST case number 84 of 2017 in acquitting the respondent number 2, Karthiko Gowda, of the charge under section 341, 324, 307, 506 by 34 of the Indian Penal Code. The prosecution case, as per the written report submitted by the appellant before the officer in charge of Purushottampur police station, is that on 14/11/2016 at about 8:45 a.m., his son Surendra Gowda bracket PW2 was standing in front of his house. At that time, the respondent number 2, Kartika Gowda, along with 2 others, namely Gantei Gowda and Pori Gowda, being armed with Parsuram Tangia sword and Kati, attacked him with an intention to kill. It is stated that the respondent number 2 gave a Tangia blow on the head of PW2, and to save his life, PW2 ran and entered into Dhoba's side. Stop. Subpara. On the written report presented by the appellant, Purushottampur PS case number 172 of dated 14/11/2016 was registered, and ASI R.S. Rao bracket PW10 took up investigation of the case. Stop. During course of investigation, the IO examined the informant, visited the spot, examined other witnesses, and also the injured on 15/11/2016 at Som Hospital, Bhubaneswar, and issued injury requisition. He conducted raid and arrested the respondent number 2 and forwarded him to court of Lieutenant JMFC Purushottampur. During course of investigation, the IO didn't find any material against co-accused Pori Gowda, and accordingly, on completion of investigation, he submitted charge sheet not only against the respondent number 2, Kartika Gowda, but also against co-accused Gantei Gowda, who faced trial along with the respondent number in ST case number 130 of 2017, and by common judgment and order dated 21/1/2018, he was acquitted of all the charges. In order to prove its case, the prosecution examined 11 witnesses, PW1 is the informant, PW2 is the injured, and PWs 3, 4, 5, 6, 7, and 9, 8 and 9 are the occurrence witnesses. PW10 is the investigating officer, and PW11 is the medical officer. The London Trial Court, after assessing the oral as well as documentary evidence on record, has been pleased to hold as follows. Quote paragraph number 15. Law is well settled that the appellate court should deal with the reasons for acquittal and interfere only if the acquittal is perverse. The appellate court has to consider the fact that the trial court has the benefit of seeing the witnesses in the witness box, and the presumption of innocence is not weakened by the acquittal. If two reasonable conclusions can be reached, the appellate court should not disturb the finding of the trial court. If two views of the matter are possible, the view favorable to the accused should be taken. An order of acquittal should not be set aside unless there are some compelling reasons on account of misappropriation of evidence, and ignorance thereof. If the judgment of acquittal is unreasonable and when admissible evidence is ignored, the appellate court would interfere with the order of acquittal. Keeping in view the settled principle of law and after going through the materials on record, particularly the reason assigned by the London trial court for acquitting the respondent number 2, it appears that the medical evidence indicates that the injury was caused by a blunt object, whereas it is the prosecution case that sharp cutting weapon has been used to assault the injured. The prosecution has not brought any clarification from the doctor as to whether the injury caused on PW2 is possible by Parsuram Tangia or not. Not a single eyewitness, including the injured, has stated that blunt side of the sharp cutting weapon was used during the assault. The weapon of offense was not seized, and the place of occurrence, as stated by witnesses, are also contradictory. I am of the humble view that the reasonings assigned by the London trial court in acquitting the respondent number 2 of all the charges cannot be said to be perverse. There is nothing on record to show that material evidence has not been taken into account or the finding is based on inadmissible evidence. After hearing the London counsel for the respective parties and going through the impugned judgment record, I am of the humble view that there is nothing to interfere with the impugned judgment and order of acquittal. Accordingly, the criminal appeal stands dismissed.
So item number 44.
Yes, Bobita Sahu, Mr. Sushant Kumar Tripathi, not there.
Surrender certificate not filed.
All right, none appears for the appellant. It appears that the appellant was granted interim bail for a period of 3 months as per order dated 3/5/2023 in IA number 1082 of 2019. And the London Council for the appellant was directed to file the surrender certificate of the appellant by the next date. Since the London Council for the appellant is not present and no surrender certificate has been filed, let a report be called for from the London Trial Court as to whether the appellant has availed the interim bail order as per order dated 3/5/2023 or not, and if so, whether he has surrendered at the right time or not, and if not, what steps have been taken against him for his arrest as well as against the bailers. Copy of the order be communicated by email by the London Registered Judicial to the concerned court, and report be submitted within such and such period. The matter be listed on such and such date with the report of the London Trial Court. Yes.
Item number 49.
Zero 5/21. There are two accused, Malay Swami and D. Selvan. I have filed power for both of them, Lords. Even in the last date of hearing, I had personally appeared in this matter, but the orders is not showing my name, Lordship. So others' name may be deleted. And Lordship, I am in JC since July 19. So Lordship, more than 4 years and 2 months of JC. I am just pressing my IA 1080 for bail, for regular bail and for suspension of sentence, Lordship. So if any early date may be fixed for the hearing, and I have supplied the deposition copy also to this honorable court and to the learned
No, Mr. Manohar, the paper book has to be prepared. If you can prepare the paper book, it would contain everything. Not that this only evidence copy, but all other things are also required. There is a format how the paper books, so what the paper book should contain. And if you yourself prepare, it is well and good. Then you can file it once it is verified, and it will come for acceptance of the paper book. Thereafter, a date can be fixed for hearing, because according to you, you have undergone 4 years and some months. So,
yes, Lordship.
But for bail, you are to wait till you at least complete half of the substantive sentence, because it is 10 years, and you yourself say that you have just undergone 4 years
4
and
years
2
2
months.
Lordship.
So option is with you. Either you prepare the paper book or you wait for some time. I am just adjourning the case.
Lordship,
Are you have you taken instruction whether you are ready and willing? Your client is
yes, my
ready
lord.
and willing.
Yes, Lordship.
So get the
you want a hearing
paper
on
book.
bail, on the bail at least.
No. Get the paper book prepared if you so like, and file it. Yeah. Otherwise, you are to wait.
Yes, Lordship.
Okay. Mr. Sam Manohar, London Council, appearing for the appellant submitted. that he wants to obtain instruction whether the appellant is ready and willing to prepare the paper book and file the same. So,
Yes, Lordship.
can it be, you want it to be, I am listing it on 25th. If you say, okay, I am ready, then
Yes, Lordship, I am okay, Lordship. I am okay. I have
okay,
the
then submit
clear
that petition.
instruction.
All right. The appellant is ready and willing to prepare the paper book. Okay. How much time you want actually?
Lordship, I am not much aware with the practice of this one. High
No,
Court,
I'm granting you 1
Yes.
month time because
Lord.
there is a format you go through the what are the required documents apart from
Yes.
evidence, the judgment copy, appeal memo, chemical
Lordship.
assumption report. There is a form there.
Okay.
Is there.
Yes,
Okay,
Lordship.
so file it in accordance. Once 1 month time is granted, and after
Lordship.
if required numbers of paper books are filed,
Yes,
the
Lordship.
registry shall verify the same, and if it is found to be ordered,
Yes,
then it
Lordship.
will be placed for acceptance. Okay.
Yes, Lordship.
All right.
So any date by the end of November, Lordship.
I am granting you 4 weeks time to prepare
Lordship.
the paper book and file. Once
Yes,
you
Lordship.
file the registry will verify it, and if it is in order, it will be accepted. Then the date will be fixed for hearing. Okay.
Yes, Lordship.
All right.
Item number 54. May it please, my lords, on behalf of Mr. Panda.
Yeah.
Lords, I have been charged under Section 20B2C of the NDPS Act for a substantive period of 10 years and fine of rupees 1 lakh. And I have been in custody, my lord, since 30/8/2015. This is an appeal after
10 years,
conviction.
yes. So that ये trial court record bhag final form. What is the name of this appellant?
Lords, there are two appellants. One is Honoka Sabbar.
You have filed this application for bail of both the appellants.
My lords, they're both the appellants.
Okay.
Two appellants
The final form indicates that they are in custody. They were taken into custody on 31/8/2015.
Okay.
So they were never released on bail during trial.
No, my lords.
Let
But
us
my
see.
lord was pleased to grant me an interim bail. And
Just no. I first let us see that whether you are being released on bail during trial or not.
the alleged quantity was near about 4 quintals.
Just a minute. So and so custody. Produced from custody. No, they were never released on bail. Then before this court in the criminal appeal department.
My lords, that is why order number 6 dated 11/7/2022.
Order number 6.
Again.
bail ହେଇଥିଲା ଗୋଟେ
Again, 3 months. And I have surrendered.
अच्छा 11/7/2022 रे 3 months bail दिया ହେଇଥିଲା. ठीक समझ surrender
Again, surrender certificate is filed, which is dated 23/10/2022. That I had filed earlier, my lords.
ତାପରେ ଆଉ ଯାଇନାହାନ୍ତି?
No, my lords. On the last occasion when the appeal was taken up, there was a noting that the appeal is ready for hearing. That is what it was reflected.
Surrender certificate କାହିଁ କହିଲେ?
My lords, I have a copy. May I please?
ଦିଅନ୍ତୁ.
Again.
Yes, Mr. Tripathi. ସେ 2015 ମାନେ 8 ବର୍ଷ ହେଇଗଲା କିନ୍ତୁ ଏଇ ଯୋଉ 3 ମାସଟାକୁ ଯଦି ଆମେ ମାଇନସ କରିଦବୁ ତାହେଲେ ଆସୁଛି 7 ବର୍ଷ
9 ମାସ
ଆଉ 9 ମାସ ରହୁଛି। ଏଇ ଯୋଉ ଅନରେବୁଲ ସୁପ୍ରିମ କୋର୍ଟଙ୍କର ଯୋଉ ଡିସିସନ ଟା ରହିଛି 7 ବର୍ଷ 6 ମାସରେ ଯୋଉଟା ଛାଡିଥିଲେ ଯୋଉଟା କମ୍ପ୍ଲିଟ ଫୁଲ କଣ ସେ
Mohammed Muslim
case had the
during trial.
had the learned counsel for the petitioner learned counsel for the state. The learned counsel for the petitioner submitted that the petitioners were taken into judicial custody since 31/8/2015 and they were never released on bail during trial and during pendency of the appeal they were directed to be released on bail for a period of 3 months as per order dated 11/7/2022 and after availing the same the petitioner surrendered at right time. Has produced the surrender certificate. Learned counsel further submits that in view of the ratio laid down by the Honorable Supreme Court in case of so and so, the petitioner's bail application may be favorably considered even though it's a case of seizure of commercial quantity of ganja and bar under section 37 of the NDPS Act is applicable. The learned counsel for the state oppose the prayer for bail. In case of so and so से जोटा relevant paragraph गुड़ा को जो quote हुए था copy करी paste कर देवे. Considering the submission made by the learned counsel for the respective parties, the sentence imposed by the learned trial court period already undergone by the petitioner in judicial custody, conduct of the petitioner in complying with the interim bail order, and taking into account the ratio laid down in the case of Mohammed Muslim, I am inclined to release the petitioner on bail allowed.
Grateful, Millards. Millards, I have filed the certified copy of the surrender memo today. That
Okay.
was a Xerox copy, if your lordship will.
Surrender certificate যদি ଅଛି ଦେଖ ଅଛି ତ then it's all right.
Grateful, Millards. Deeply obliged.
Yes.
Item 55, man.
Item number 55.
May I please your lordship? They're almost same as the last case, my lord. Here it is a case of conviction under section 20B2C of the NDPS Act, and the petitioner.
What is the sentence imposed, Mr. Panda?
15 years and 2 lakhs without considering section 32B of the NDPS Act, without assigning any reason.
Let us come to the operative part.
My lord. Interim bail ଯାଇଥିଲା. Your lordship has observed that in the.
Okay.
Now,
what period you have already undergone?
More than 8 years. More than 8 years.
Oh, which order I have discussed all these things?
Order dated 1/8/2022. And he has surrendered flag F. Your lordship, the surrender certificate is at flag F.
ଏଥର କେତେ ମାସ ଦିଆ ହେଇଥିଲା 3 ମାସ
3 ମାସ
ଠିକ ସମୟରେ ସରେଣ୍ଡର
ଠିକ
କଲେ
ସମୟରେ।
ସେତେବେଳେ ନୋଟେଡ ଡାଉନ ହେଇଥିଲା ଯେ 7 ବର୍ଷ ଆପଣ ଇଏ
ସେତେବେଳେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ମଗା ହେଇଥିଲା which is on record.
ହୁଁ
And he has been arrested.
କେତେ ଆସୁଛି କଷ୍ଟଡିରେ
30/5/2015
2 दिन 23/7/2022.
କେତେ କେତେ
2602 days.
ନା ମୁଁ ସେମିତି କହିଲେ ହବ
ନାଇଁ,
7 ବର୍ଷ
8 ବର୍ଷ 15 ଦିନ
ଆଜିକୁ ହିସାବ
excluding the period of interim bail period.
କେତେ ବର୍ଷ 8 ବର୍ଷ ହେଇଯାଉଛି
8 ବର୍ଷ 15 ଦିନ।
ଅଲରାଇଟ୍ ସେଇ ଟାଇପର ଅର୍ଡରଟା କରିଦେବେ ହେଲା ସେ କଷ୍ଟଡି ଡେଟ୍ ଦେଖେଇଦେବେ ଲେଖିଦେବେ ଫାଇନାଲ ଫର୍ମ ଦେଖେଇନି 8 ବର୍ଷ ହେଲାଣି ଯାଇଥିଲା ଇଣ୍ଟରିମ୍ ବେଲରେ ଠିକ ସମୟରେ ସରେଣ୍ଡର କଲେ ବେଲ୍ ଆଲାଉଡ୍
Sub item.
Sub item re bail application nahi to? Yes. This bail order was passed in 28 of 2022. Okay, next.
Item number 56.
Mr. Rajiv Lochan Patnaik.
On behalf of Mr. S.K.SAHOO.
Okay. Karibe na adjournment nebe.
Here, the petitioner is in custody being challenging the order of landed
Offense kono?
22B of the NDPS Act.
Kete varsho hichi
7
sentence?
years, Lordship. 10 years imprisonment.
7 years complete ହେଇଗଲାଣି? Bail ରେ ଯାଇ ନଥିଲେ ଜମା? ଦେଖିଲେ LCR କାଢିଲେ? ଜଣେ appellant?
My lord, the other one has been released on bail, Narendra Singh.
Narendra Singh released. ये appellant ର ନାଁ କଣ?
Suma Prasad.
ସୁଷମା ପ୍ରସାଦ ଦେଖୁଛି 12/8/2016 ରେ କଷ୍ଟଡି କି ଗଲେ। ତ ଦେଖିଦବା ଆପଣଙ୍କର ଅର୍ଡର ସିଟ୍ ବେଲ ରେ ଯାଇଛନ୍ତି ନା ନାହିଁ। accused so and so produced in custody. Okay. Produced in custody. Produced in custody. नहीं बेल ले जाएंगे ट्रायल बेले जाएंगे तापर ये हाई कोर्ट रे जाइनी तो 2016 ले आपनकर हेगला 7 वर्ष आउ गोटे मास होउची यस मिस्टर त्रिपाठी से डेट देखि जंतु 12/8/2016 एटा सबको सही रेशियो पके देबे और ता छडा लेडी लिखि देबे 437(1) बेल अलाउड नेक्स्ट स्टे रिलेशन ऑफ फाइन
Item number 57.
May I please your lordship?
Lord, IA number. आपण पाइछन्ती कॉपी आईए
बेल पाइछि
1100 देखिले कोन फास्ट देखुन 1100 of 2022 এটা হচ্ছে বেল অ্যাপ্লিকেশন ଆଉ ଷ୍ଟେ ରିଲାଇସନ ଅଫ ଫାଇନ ର ତାପରେ କିଛି ଅର୍ଡର ହେଇନି
ନା ମିଲର ୟା ଧରେ LCR କଲ୍ ଫର
ଟିକେ ଟିକେ ସେ
ଯେହେତୁ ଗୋଟିଏ କନେକ୍ଟେଡ କେସ୍
ୱେଟ୍ ଲେଟ୍ हिम सी ଏଟା ଦେଖ ଆମର ରେକର୍ଡ କ୍ରିମିନାଲ ଆପିଲ ପ୍ରଥମଟା
ଲାଷ୍ଟ
ପ୍ରଥମଟା କହିଲି ପରା ହଁ ଏଟା ତ ମୂଳରୁ ଆଡମିଟ ବି ହେଇନି ହଁ
there was a order miller
अच्छा
one of appeal arising out of one GR case criminal trial that's why my lord tag
ट्याग जे आपण जजमेंट रो सर्टिफाइड कॉपी जदी फाइल करनांती सेटा जदी कनेक्टेड केस रे फाइल करचंदी ताले आपनको तरफ रु गोटे इंट्रीम एप्लीकेशन फाइल हवा कथा नै कि डिस्पेंस विथ टू फाइल द सर्टिफाइड कॉपी आ कोन एगुडा कहियो पड़िबो ना कोन फाइल करंतु तापरे लर्न एंड काउंसिल फॉर द appellant 6 for an adjournment to file an interim application for dispensing with filing of the certified copy. List this matter immediately after the interim application is filed. Yes, next.
Second item be
59.
ତା ସାଙ୍ଗରେ ଆସିବ।
Also granted interim bail by the order dated 4/5/2023.
କଣ ହେଇଛି?
4/5/2023, your lordship granted interim bail for a period of 3 months, and I have surrendered. Today, my lord listed for the filing.
The land
Surrender
counsel for
certificate.
the appellant files the surrender certificate, which is taken on record. All right. Okay, pass over Coram. Next.
Item number 66.
Also not there. अच्छा এটা pass over କରନ୍ତୁ ଗୁରୁବାର ଦିନ take up କରିବା।
Item number 68.
ଆଉ ବାକି ତକ ଗୁରୁବାର ଦିନ ନବା।